And welcome to another edition of the Freedom from Religion Foundation's Ask an Atheist on Facebook Live. I'm Dan Barker. I'm co-president of the Freedom from Religion Foundation. And with me today are two of FFRF's attorneys, Patrick Elliott and Liz Cavell. In the past, we have reported many state church legal victories on this show, but we can't win them all. We should win them all, but sometimes the courts get it wrong. Today, we'll be talking about a recent bad decision in FFRF's case challenging a Pennsylvania county's official seal, which includes a large Christian cross. And as always on Ask an Atheist, you're welcome to submit questions, which we will try to answer during the show. Feel free to submit them in the comments below, or by emailing us at askanatheist@ffrf.org. By the way, this is our 100th show. FFRF's Ask an Atheist started more than 2 years ago, and I think we should recognize the people who make this show happen. Can we look into the control room? There we go. On the left there is Bruce Johnson, who's our director, and on the right there's Noah Gilfillan, who's doing sound. Say hi, Noah. Hi, Noah's with Audio for the Arts. And can we see Lauren over there? Hi, Lauren. Lauren is the producer of the show. She handles the teleprompter, and you can see the teleprompter up there, right? All the words that it looks like I'm saying spontaneously, they're coming off of Lauren's prompter. And she also handles the questions. So, congratulations for 100 shows. And there's another reason to congratulate this week, this month, and that is that Patrick became a father last week. So, are you the unholy father? The holy?
I am. I am a very unholy father, but a happy father.
So just on August the 5th, by the way, I looked that up. August the 5th is Ellery Schemp's birthday.
Oh, cool.
Ellery Schemp, the famous litigant in the Schemp decision in the schools. So congratulations, Patrick. And so let's get back to the Pennsylvania decision. Before we talk with Liz and Patrick, we have a brief clip of some news that aired 3 years ago. I think 3 years ago this week.
It's the emblem of Lehigh County, displayed on government buildings and official documents.
I get it with my water bill, I get it with my garbage bill.
Look closely and you might see why the county seal and flag don't fly for everyone, including Candace Winkler.
The cross is literally a symbol of Jesus Christ's crucifixion. There's a constitutional law about separation of church and state, and it seems very simple to me.
So earlier this week, Winkler, along with 3 other Lehigh County residents and the Freedom from Religion Foundation, filed a federal lawsuit against the county. It alleges the Latin cross at the center of the seal violates the First and 14th Amendments and excludes those who are not religious.
I do pay taxes, and I think that my voice does matter, and I think the constitutionality of the issue matters.
But some residents, like John Pearson, want the seal to stay the same.
I've been here 38 years and I think it looks fine. If you want to put 2 seals on it, that's fine, but you know what, don't take what's good off. The cross is good.
Similar lawsuits have been filed across the country, says attorney John Dorsey of the Power 10 Legal Group, who is not related to the case.
Anytime you raise an issue where the government seems to be imposing or endorsing one religion to the exclusion of others, even those who do not have any religion, it can be interpreted as infringing on their right.
In a previous letter responding to the foundation, county officials wrote, quote, "It is the position of Lehigh County that the presence of the cross on the seal, among other items of historical significance, has the secular purpose of recognizing the history of the county."
So it seems pretty obvious to me that when you look at that seal, there's this big Christian cross right in the middle. What other message can you get? But what that guy said, Christianity is good and it's part of our history. So Patrick, you've been involved in this case since the beginning. When was it, 3 years ago?
That's when we filed, but our involvement went back even further than that, asking them to address this before a case, before we even went forward with the case.
So can you bring us up to date? I mean, kind of give us a little bit of the history of our involvement in the lawsuits.
Yeah, sure. So again, we filed in 3 years ago. Prior to that, we wrote pointing out basically what courts across the country had already decided was that using the preeminent symbol of Christianity, the Latin cross, on a government flag or government seal is unconstitutional. And here they really used as you saw in part of the video, they use the seal throughout the community. They've got it in their like commissioner's hearing court, their commissioner's courtroom. They have it on the outside of government buildings, on county documents, every page of the county website. So it's not like this is just some government symbol that's been put away. They've really embraced it and are using it today throughout the county.
Well, when I flew to the Allentown airport a few months ago, which is the county seat, isn't it? Allentown's the county seat. It was right there on the wall in the airport, a big symbol.
Right, and they had fly it on the flag. So there's a flag at the county airport. So we went forward with a case, as you met one of our plaintiffs in the video, but we had 3 other local plaintiffs who opposed their government symbol being this Christian cross. And we filed suit in the Eastern District of Pennsylvania in federal court. And then in 2017, we won. The district court agreed that, which seems obvious to us, is that this is the symbol of Christianity. The government can't adopt that symbol. It violated, 2 prongs of the Lemon test, basically being an endorsement of religion, but also that the original, purpose of adopting this as the county's symbol was a religious purpose. There was not really a good secular justification for that, and so we won. And that could have been the end of the story, which it seems like it should have been. The county could have did what we asked, which is to redesign a seal, that's more inclusive to everyone in the community. But a religious group came in, Beckett Fund, said, hey, we'll represent you on an appeal. And so they then appealed to the Third Circuit. And that's where we are today. That was the decision that the Third Circuit recently ruled on the case, overturning our original victory.
So, Liz, we were winning. We had a strong, good arguments and good legal precedent. So what went wrong?
Right. So, like Patrick mentioned, we won at the district court level, with the district court kind of applying the prevailing legal test, which is the Lemon test that Patrick mentioned, which is basically an analysis of whether or not a government action endorses religion, or has a religious purpose, or a religious effect. And so the court rightly, I think, found that the adopting a Christian cross as the symbol and seal of the county failed that test, and so we were winning. So while we were on appeal, the Supreme Court took a case evaluating an actual cross monument on public land in Maryland. That was American Legion case, also known as the Bladensburg, Maryland Peace Cross.
Which we talked about on this show a couple weeks ago, right?
That's right. So while our case was pending before the Third Circuit on appeal, the Supreme Court came down with their decision in American Legion, basically upending the test that's used to analyze religious symbols on government property, and they sort of signaled in their opinion that that courts should use this new American Legion analysis when they're evaluating government monuments, symbols, or practices that involve kind of longstanding monuments and symbols. So the Third Circuit, in light of the American Legion decision, was the first case that we know of to really apply that analysis.
But the Supreme Court said it is okay to have Christian crosses on government property then?
Well, in the American Legion case, the Supreme Court said, as we talked about a couple weeks ago on this show, that the cross that was being challenged in Bladensburg, Maryland, the Peace Cross, which was also purportedly a war memorial to World War I veterans in the area, that given its history and its sort of evolving purposes over the course of its longstanding history, didn't offend the Establishment Clause under this sort of new squishy analysis that doesn't look into religious purpose, kind of throws up its hands and says, well, we can't really divine the purpose of something that's old.
Because it's no longer religious, right? It's no longer a religious purpose?
Well, there's sort of a dash of that. The purpose sort of evolves to be more secular over time when it's a long-standing monument. The court sort of paid some lip service to that. And also the idea that the purpose can change over time or multiply, in the words of the court, over time. And so it's basically just we're not really going to be too discerning about the purpose when it's a long-standing symbol. We're going to give it a presumption of constitutionality.
So, Patrick, the Supreme Court, the Third Circuit took the Supreme Court's, squishy, bad reasoning, and then they applied it to the seal in Pennsylvania. Is that what happened?
Yeah, and I think, which we argued, we did file the court asked for additional, like a supplemental brief. And so we really pointed out that there's a problem or a difference between, a cross on public property that was, when it was put up, was designed as a war memorial, to the government today using the symbol of Christianity as its own symbol. Is that there's quite a bit of difference between that. And that's really not surprising, because there are a number of other courts across the country that have ruled that, cities can't adopt religious symbols as or even included on their seal or their flag. That includes courts that people may well consider conservative courts across the country, and courts of appeals have ruled that way. So we were really hopeful that the court would, while Bladensburg was an unfortunate decision, that it might not apply in an unfavorable way here, given the type of violation. It's not just a violation of seeing something on one place in government property. It's our plaintiffs complained and saying, their tax bills, they go to get permits. To any government interaction they do involves the cross. It's the thing that you'd see in a church. And here their county commissioners' hearing room, so where their county decisions are made, they have a huge seal behind where the decisions are made, and they put them on TV monitors that are up in the room. So it's really been just embraced by the government in a way that I think impacts people that are there who aren't Christian, including our four plaintiffs who are members. We have many other members in the county, but I'm just glad that that we were able to at least pursue this on their behalf, because I could see, I wouldn't want that to be my county, to be embracing that religious symbolism.
So wasn't there precedent, previous county seals that have been found unconstitutional? I think in Redlands, California, wasn't there one? My brother was involved in one of those cases.
There's been a few. So I'm most familiar with the ones that ultimately went to the Circuit Courts of Appeals. So there's been ones in the 7th Circuit, where we are, the 10th Circuit, and the 11th Circuit. So there's been a number of courts of appeals that have had to resolve this issue and say, you can't do this. Some of those decisions go back to, the mid-1990s. So it's not like this is a new thing or very, very old cases. But pretty consistently, courts have recognized that they can't be doing this. So I think that this is a departure from the precedent before, and Bladensburg is maybe the avenue that the court was looking to do it. I laughed when Liz mentioned the idea that we can't figure out the purpose behind the county adopting this in the 1940s, but we're supposed to be able to divine what the founding fathers of this country meant when they adopted the Establishment Clause. So I think some of our Supreme Court justices really embrace an approach of figuring out exactly what some of the founders, I guess, thought about what the Establishment Clause meant, but they're not at all willing to engage in that in much more modern practices, because they don't like where it might lead them, which is to strike down this type of symbolism.
So there is a point, I think in the decision maybe they mentioned that there are some things that truly have been secularized. The city of Bethlehem, Pennsylvania, for example. No one complains that there's a religious name to the city, because by now everyone's accepting it as just a name. Is that a good argument?
I think it's a favorite argument of the courts that want to sort of give a blessing to these types of practices, because it sort of strikes people as absurd that you would go around, making Bethlehem change the name of their town, that would be so disruptive, and that it's somehow just shows a sensitivity of the person complaining. But again, whether or not that's true, and whether or not that's comparable in terms of what the purpose was, if you go way back when to whenever someone named the town, What we're talking about with the county seal, like Patrick mentioned, and like we tried to explain and convince the Third Circuit, this is something that is, I say all the time, it is literally the stamp of approval of the county. I mean, I'm sure somewhere there is a stamp pad with that bad boy, embossed on it, and the county goes on day in, day out, sort of disseminating it to its people. It makes the choice every time it builds a new building. It makes the choice to plant that flag in the ground with their Latin cross flying, and every time it orders a new box of letterhead, it makes the choice to put that symbol on it. So it's disseminating this stamp of approval of the county that strikes a lot of its citizens as an endorsement of Christianity for obvious reasons.
I think, they also, and this is where maybe I would agree with some of the judges in deciding whether something has lost its religious meaning. Bethlehem, Pennsylvania has lost that. That's the name of the town. If you live in Lehigh County and you think of Bethlehem, you're associating it with a place. It's the city that you're talking about, where I don't think we've had that culturally in the U.S. with the cross. The cross, both the supporters of keeping it know that it means the death and resurrection of Jesus in their minds, and us who are non-Christian think they want this here because they think it symbolizes Jesus and his resurrection.
And as courts have pointed out, truthfully, up until the American Legion case, courts have accepted that the Latin cross is a symbol of Christianity and has no secular meaning in our culture.
The Latin cross is the T-shaped basic Christian
cross-shaped monuments, as is the common ridiculous parlance that tries to secularize, these endorsements of Christianity.
I guess one way to look at this is to ask, after this decision came down, who is celebrating?
Right.
Are the atheists in Allentown going, yay, our secular symbol has been preserved? Right? Everybody knows what's going on here. Right. And don't you think, maybe I'm cynical, but don't you think this is kind of the fallout from Trump packing the Supreme Court with conservative justices? Now the religious right feels emboldened, even religious right on the courts.
We've seen that. I don't think it's even speculation that in our cases, because we have, I don't know what our current docket at is, usually between 12 to 15 ongoing cases, that cases that we won definitively, like Lehigh, where it didn't really seem that there was an option for appeal. The other side is appealing all the way, hoping to get to the Supreme Court, because they certainly view this court as being favorable to them in every respect. And I think with Merrick Garland being on the court, rather than Gorsuch, there would be very much a difference.
A swing, at least.
Right. And, I think the other side perceives that. So that's what we're seeing in our cases, is that appeal all the way to the Supreme Court if we can. Unfortunately for us, the Supreme Court has even taken one of those cases. There's a case this next term that the court will be taking on school vouchers out of the state of Montana, where the state of Montana said that their state constitution prohibits funding of religious schools. And the state Supreme Court has authority to make that determination, but that's now been appealed to the U.S. Supreme Court, saying that would violate like free exercise rights of parents or equal protection. And so we now have the Supreme Court wading into whether some federal law would trump state constitutions that help protect state-church separation. So that's a really concerning case that they even decided to take. So I think you're right that I think the other groups kind of see an opportunity. Hopefully the court really won't press that further than cases like we've seen, like the Bladensburg Peace Cross case. But it's concerning that that's a trend that we're observing. Well,
the religious right's probably saying, yay, the Supreme Court's on our side, and even though it was a little decision, that signals to us that we can go ahead and they gave us an inch, we'll take a mile. Isn't there a silver lining in this, in Bladensburg and maybe even in Lehigh, in that these bad decisions are only applying to older crosses? I mean, they're using a historical, time has passed. What if a city today wanted to change its seal to put a cross on it? Would that hold muster?
Right. So you're right that the Bladensburg American Legion case a big dimension of that has to do with the long-standing historical nature of the monument in that case. The Third Circuit in Lehigh, when it was evaluating the county seal, riffed right off of that in sort of saying this has been, the county seal since the 1940s or whatever it was. And so therefore there's this long history and evolving, sort of purpose and effect of having this on the seal that is different than something that were adopted tomorrow. And it also, in the view of the court, I think, and I think, this is a little bit we talked about of a cop-out, but when they're evaluating purpose, whether or not something has a religious purpose, they've sort of used the historical or long-standing nature of the monument or the symbol to sort of avoid analyzing what the true purpose is, because there's sort of this idea that we can't know the true purpose of something that was done, 100 years ago or
the
70
purpose
years
has changed since then.
Right.
Is what
Or the purposes have evolved and changed or multiplied or whatever. And so something that, is happening right now, like, we can talk about Arkansas's Ten Commandments monument, something that the government is adopting or putting on public property or designing its seal right now and adopting religious symbols. It'd be a lot easier to make the argument and adduce the proof that there's a religious purpose or there's no secular purpose. And so we're hopeful that going forward we can still challenge monuments, symbols, things in that category that are popping up new.
And that would still be based on at least the principles that are in the Lemon Test. I mean, a secular purpose and a secular effect and all of that. So.
Right. I mean, it takes the wind out of the analysis in the Bladensburg Cross case and this Lehigh Seal case, because much of that analysis involves sort of giving a presumption to these historical and long-standing things.
So it looks like the court is saying there's a statute of limitations on crosses. What is that? Right. If someone did it last year, we could challenge that. Well, like in Arkansas. But what's the point in history where the court will say, well, it's been long enough now, it's now, I mean,
right.
Where is that point?
Right. We don't really tolerate that when we're enforcing any other constitutional rights, right? Like there's been points in time where the Supreme Court makes a decision and says, no, what was ubiquitous across the country was wrong, whether that, that they could enter into any number of issues. I mean, one might be like Loving versus Virginia, interracial marriage. Well, that was obviously the rule for a number of the law of the land in Virginia for however long, until the Supreme Court stepped in to say, no, this violates the Constitution,
right.
Including the 14th Amendment. But I think that it's really lazy legal analysis to say, oh, maybe there's this time window, we don't know how long it would be, that older things are now going to be okay. Unfortunately, that's the world we've been living with even since 2005, because you had those Ten Commandments cases in 2005 where a really old one was allowed to stand at the Texas Capitol and a new one was struck down. So we've already kind of been in that realm since 2005 with the Supreme Court. So it's not anything new. It's just as far as being a lawyer, it bothers me because I don't think that's like a sound legal principle to say we allow things that if things have been going on long enough, we think they're okay. And that's really not how the First Amendment should be enforced or interpreted.
Right.
So I don't know if we should talk about this on live TV, but is this going to affect our own internal legal strategy about what cases we might take and about what issues we might look the other way on? Or is that something for a future show?
I mean, I think it's obvious for any group, including, the Freedom from Religion Foundation, what the Supreme Court's decisions are going to guide what challenges you take or don't take. So something similar to Bladensburg, a war memorial cross of that age, is probably not a case that we would be likely to take because Bladensburg would so aptly apply. But in some sense, it may be reason for us to take cases on new displays, because if we let them stand for too long, they may well get that vintage that would allow them to be okay. So I do think, in some sense, it means you're on the brake, and in some sense, it means you're on the gas if there are cases that should be challenged today rather than letting them sit for too long. They may well not be able to be challenged.
That's right.
So there are cases that we took and won in the past that we might not take today because of the change in the court. Like Santa Clara, for example.
Yeah, I mean, I think everyone's in that boat when it comes to crosses because, I mean, as we've already mentioned, the American Legion case opinion from the Supreme Court really is a departure from what was more or less unanimous circuit courts of appeal on the question of whether or not a cross on public land, a cross being endorsed by a government actor, violates the Establishment Clause. There was a strong body of law supporting that principle, and so American Legion really is a departure on that. So us and everybody else is really having to kind of rethink how we view cross cases in particular, and of course historical and long-standing monuments in general. But again, like Patrick said, we were doing some of that analysis already in light of Van Orden, the old Ten Commandments cases that have been muddying these waters for a decade.
The Lynch dynamic of whether it's surrounded by enough secular stuff, all of that. But you know, the case we won recently, when did we win Santa Clara? Like 2 years ago?
Within the last 2 years, yeah.
Where we actually got them to move a big Christian cross from public land to private property. Today, would we take that case?
I think actually there's an argument to take it under the California Constitution, which also has strong state-church separation enshrined in it. So just because we took a case in the past that might not prevail today under the Establishment Clause, there still might be a state right, to challenge it. And that's what happened in some other recent cases, like in Oklahoma in the last few years, where their state Supreme Court unanimously struck down a Ten Commandments monument that was at the state capitol. And so if you live in Oklahoma, you don't have to just rely on the Establishment Clause. You have a state constitutional protection. So it's hard sometimes to go back in time and apply this. But I was reminded by kind of what you hinted at, Dan, a little bit of the cross not being religious. Is I think maybe be careful what you wish for with some of these religious groups. Is now they're important religious symbols. I think the cross means something to people. They wear it. It's adorned on their churches. Are you devaluing a religious symbol by arguing that it should be that it's secularized in some sense? So I do think both with prayer and with religious symbols that people who are religious should be careful about making these arguments, because you're really somewhat decreasing the importance of a religious symbol and its importance to the religion when you're arguing that they should just be anywhere and don't have special significance.
So maybe there's some little dishonesty there where they're saying we should keep the cross that we love so much because it's not really religious. I mean, they're talking out of both sides of their mouth, aren't they?
Well, and also pumping the historical piece, I think, is important. Because, I mean, clearly, obviously, what's being winked at and bargained for in that, what you're talking about, is it's Christian nationalism. It's, it's promoting the idea that these counties and communities have a history of being Christian or have a Christian founding, and that, that in and of itself is secular somehow, we can't help it if we're a Christian nation kind of thing, or we're a Christian culture. And the bargain being made is, maybe it sort of devalues our religious symbols, but what we get in return is, of course, what the Establishment Clause is meant to protect against, which is government endorsement of our particular religion and, a sort of infusing government and patriotism with our brand of religion. And of course, that's Christian nationalism.
So before we go to questions, unless you have something else you want to say, I want to bounce off of that, because I read that in Pennsylvania, in Lehigh County, they were arguing that this reflects the roots of our founding of this community, when actually people were living in Pennsylvania for 15,000 years before it was founded by these Europeans who came over here with guns and Bibles and said, we are now a Christian. So isn't there a little tinge of American, not just nationalism, but superiority over the people that we invaded?
Right. It's certainly insensitive to, to Native Americans and populations that had been here. And I don't know that they exactly said that this was the founders. The actual wording, I think, that was adopted when the seal was approved was that the cross signifies Christianity and the God-fearing people who are, I think, the foundation and backbone
of our county.
Of our county. So I think they're kind of saying exactly what you're saying, Dan, but they're being even more explicit, saying it signifies Christianity. So you're right. I think to have this view of the founders, what's going on in their head is white settlers who came and who were Christian, and not taking into account at all populations that had lived there for as you said, for many decades and 1,000-year plus prior to that.
So it's triumphalism, isn't it?
It's Christian supremacy. I mean, that's what it was meant to be. And the graphic that just got thrown up was a commissioner who was on the county commission at the time that the seal was adopted in the 40s. And his statement about what the purpose was, which was 2 years after they adopted the seal, was what Patrick just said. It signifies Christianity and the God-fearing people that are, the backbone of the county. And what the Third Circuit said was, well, that was one guy on the commission out of three.
He also designed the seal.
He designed the seal.
He's the guy who created it.
So he was the guy to ask. But, the Third Circuit wasn't really moved by that because, it just wasn't enough to overcome this presumption of constitutionality that we should have for these long-standing symbols. And, who knows how that's changed over time, and it's not imputed to the commissioners now and all the rest. But of course, the purpose was to sort of adopt a symbol of Christian supremacy in the county.
So you know that I'm a member of the Lenape tribe, the Delaware Indians, an enrolled voting member of the tribe because of my dad and his family. And our tribe lived in the Delaware River area in that whole part of Pennsylvania way back then. And so the suggestion that before the Christians came, there was no true morality or true virtue or true family love or true real American traditions is really kind of insulting. Of course, who's left there to complain? How many of the tribes are left there in that county to complain about that now? They've been wiped out through a huge genocide, basically. Right. Our tribe, which used to be there, migrated 6 times and ended up with about 700 members. We almost went extinct because of the loving Christians who came over here to impose it's not even a European view, it's a Middle Eastern transported to European, transported to Lehigh County. So it really is something of an insult. Yet they don't see it that way. They see Christianity as something good. So that's my rant for the day.
I like it.
Anything else, or shall we go?
We could take questions. Let's do it.
All right, here's some questions. Oops. Push the right button here. Okay, here's a question from Kate, C-A-I-T, Langfelt. Because of this case, can public schools legally display crosses inside schools like they are doing with "In God We Trust" signs?
No. So there's a couple layers there. The "In God We Trust" signs, which is kind of a separate problem, but just to address the first part of the question, which is, does this case from the Supreme Court now change the landscape within the public schools? And I think the answer to that is no. It did, I think, devastate a little bit of the landscape as it regards to monuments on public property that are longstanding, and as we've saw in Lehigh, that's also applying now to symbols, government symbols, such as on a seal. It's
Third Circuit decision, though. I mean, it's
right,
not.
That's quite right. But there's no reason to think that the public school body of case law, which has always been more of a heightened level of review, that's at all affected by the American Legion case.
And the American Legion case being one thing, but even our panel of judges in this case, the Lehigh case, said that, and said, in the opinion, basically said that this doesn't change our public school precedent. They have a footnote and citing to some of their public school cases, which have been quite strong. So this court recognized that there's this distinction, and the Supreme Court has also recognized that.
So the schools can't run around and put crosses up all over the place now as a result of this.
No, but of course we are seeing "In God We Trust" statutes being passed around the country, which is usually comes in the form of state legislatures passing some sort of law that says every school, shall display "In God We Trust" in a conspicuous place or in every classroom or something like that, which is, of course, incredibly problematic. We get a lot of complaints as those displays are going up. In God We Trust has been a difficult legal challenge to mount in the past, just to the motto, because of the uniqueness of it being adopted as the national motto by Congress. So
Which
there
should not have happened, by the way.
no,
but it
which
did.
is, I mean, in our view, clearly unconstitutional, but
Yeah.
which has been really insulated from
Yeah.
court challenges. Courts have not been willing to find the motto itself unconstitutional, but we do think that this ubiquitous display of "In God We Trust" throughout our public schools is definitely creating kind of a different situation.
And we can continue complaining about that. Okay.
Quite right.
I need to press this button one more time. Okay. Now here's a question from Lucas Swank. Is there any plan to challenge the Lehigh decision, distinguishing the seal from a war memorial, essentially arguing that the cross has a secular purpose of remembrance, but the seal doesn't have that?
I mean, I think that's effectively, what we were arguing. I mean, in terms of the options to appeal are there's not a lot of road left. I mean, you either go to the full panel of judges on the Third Circuit, so this was a 3-judge panel, or you go to the Supreme Court. And both of those are very highly unlikely to be taken. They're both quite an uphill battle. So, that's something that hasn't been definitively decided, but there's it's difficult to make that distinction. That's what we were pointing out. I do think if you had a different panel of judges, they easily could have come to the conclusion that we were suggesting, which is that these are two very different scenarios.
And we haven't decided yet legally.
No, you have a short window.
Yeah.
I mean,
Yeah.
you have a short window to do that. But again, pointing out the difficulties in doing so, I don't know that I would expect that we probably would not file additional challenges. But that's something, as the attorney, I don't get to make that decision. That's what the clients, really get to decide.
So could we look at it as a kind of damage control, just to contain it within the Third Circuit for now?
Yeah, I mean, that's really where this case applies to. So that's,
Yeah.
a narrow, I think it's New Jersey, Pennsylvania, and maybe Delaware. I'm like not just up to speed on
Yeah,
all my
that's right.
circuit states, but
That's it, those
but
three.
that's where this case applies to, and it's pretty confined to the idea of a seal from the 1940s and flag, and interpreting Bladensburg under that. The court does say, basically on a more extensive record, the outcome could be different.
Right,
So
right.
Here, we really had the statements of people who adopted it, and that's what we had. We didn't have further evidence. So the outcome might have been different had we had transcripts from everybody saying exactly why they did it. Unfortunately, because of time, we didn't have those. So I don't know that even within the Third Circuit, if this would prohibit somebody from challenging another type of display.
Yeah, of course. Joel Kaufman. Does this mean that proponents of state flags with Confederate emblems on them can also make their historical argument?
I love that question. And Annie Laurie gave a great quote to a reporter that I just spied on because I was copied on the email, that I thought was great. And it was something like, an Annie Laurie rhetorical question to the effect of, if we wouldn't tolerate a white nationalist symbol on our county flag, why should we tolerate a Christian nationalist symbol on our county flag? And I think that's perfectly put, and really gets at the guts of why this is so wrong and so offensive to so many people. I'm not familiar with what the constitutional arguments are against, or I don't know if these old Confederate monuments are being challenged in court, and if so, what the constitutional arguments are for their removal or for keeping them up. But I certainly think that is an analogous way. That's an analogous way to think of. That's what the court is doing, is tolerating things because they've been longstanding, and being willing to sort of pull the wool over their own eyes about whether or not they promote religion just because, they've been around for a long time and the community is used to seeing them. I think that's a dangerous principle to conduct constitutional analysis. And yeah, of course, that's where
I think people maybe naturally think about that because it just is another area where symbols are important. They have meaning to people. They evoke deep response, both on these, I guess, the Civil War issue and people using it for white nationalism,
Right.
people using it as part of being racist, and people using their religious symbols. They all have deep meaning. I mean, one distinction, which I'm not necessarily saying this is the way it should be, because I don't think those symbols, the flag, the Confederate flag, should be used by states. And thankfully, they've come around in recent decades to deciding to stop flying the Confederate flag in terms of a number of states. But what we have in the First Amendment Establishment Clause is prohibiting the government from affiliating itself with religion and religious symbols. Unfortunately, we don't have something affiliating the government with really horrible racist symbols. As a matter of policy, governments should not be adopting these. And so probably the best means of addressing those is for people to reach out to their governor, to their elected leaders, and to tell them to remove these. And there's very good reasons to do so. They may not have the same legal means that we have when the issue is religion, because we have an actual legal avenue to challenge them.
Right.
So most viewers of this show would know that when Liz referred to Annie Laurie, she was talking about the co-founder and co-president of the Freedom from
Annie
Religion
Laurie
Foundation.
Gaylor, who gives great quotes to the press, especially
Yeah.
her rhetorical questions, and so that was one that she gave to
Yeah.
a reporter about the Lehigh County
A
decision
great question.
this week.
Okay, here's a question from Lizzie McKinnery, if I'm saying that right. If they are saying that crosses are secular and not religious symbols, could somebody argue that the Star of David and the Islamic crescent moon and star also have a secular purpose?
I doubt it, but I do want to point out that the court in Lehigh didn't necessarily rely on the idea that the cross is secular or that the cross is not religious. I mean, there's a flavor of that when they're saying, who's to know the purpose, whether it's religious or secular, and oh boy, it changes over time, and we just don't know. But I do think that the court explicitly acknowledged in our case, in its opinion, that certainly the Latin cross has a religious meaning. It has a religious meaning today, regardless of why it was adopted, but that is not that's not the only factor to be considered in analyzing its constitutionality. And so I think that's not necessarily the reason why our constitutional challenge fails. It's sort of one thing in the mix. But I do think it's important to note that the court flat out acknowledged that, of course, the Latin cross has a religious significance to many people. It has a religious meaning. It is the preeminent symbol of Christianity. It's not denying those things. It's just saying that its use by the government as a public symbol on public property or part of the county seal, its use by the government in that way is not necessarily religious. And here's all the reasons why: because it's historical, because it's obfuscated by time, because it's gone on to also have a secular meaning in the community, etc.
So when the Third Circuit Appeals Court referred to American Legion, weren't they implicitly sort of embracing the arguments that the Supreme Court used about the changing of meaning over time?
Well, they don't really have a choice because that's binding precedent to them. If they think that case applies, they have to do whatever the Supreme Court says. So sometimes you have decisions from courts of appeals that are reluctant, but the Supreme Court said it. So here, the Bladensburg, the Supreme Court decision, does have this flair of multiple meanings or changing meanings, and we think that's odd in reference to religious symbols. I think that the Star of David and the cross have pretty static meaning in terms of what the religious significance are. So I do think there's some merit to the question that's being asked here. But Liz is right too that the court doesn't say it's a secular symbol. It kind of says, oh, it's a religious symbol, but this is the analysis that we need to do under what the Supreme Court has said.
Right.
So far, there aren't any city seals that have a Star of David or an Islamic crescent moon on it yet. Do we know of?
So there's that too.
Yeah, I mean, if there were, that would be that looks like it's a government endorsement of those religions. Right. I don't think. Doug, Robert, I see two questions on here still. Doug Roberts, I'm talking to Bruce. Bruce is talking to me in my earphone, Bruce. Two more questions. Do you feel that the Trump administration is allowing Christianity to creep more and more into political and public life?
Yes.
Yeah, I mean, I don't like the word allowing because I feel like he's like making it happen, right? I mean, the people that he has at high levels of position in his cabinet are certainly pushing religion into the federal government more than we have seen, even under a number of prior presidents, Republican or Democrat. So I don't think it's even just allowing. I think it's really there's been a push for Christian nationalism, and maybe it's because our country has become more secular. So there's this kind of holding on to a power or protecting this ideal of that we're a Christian country. So I think we're definitely seeing it from this administration, and maybe it's in part because of how our country is becoming less religious.
Maybe they're poor losers. They know they're losing. They're losing in the social, cultural sphere, and so they're trying real hard not to lose in the government.
Right, and I mean, I think one of the biggest effects that the Trump administration has had on what this questioner is asking is judges that have been appointed to the federal bench. I mean, these are judges that are they are darlings of the evangelical movement. I mean, these are the most conservative of the crop, and so they are definitely on board with religion in the public sphere, which ends up in these cases as being a Christian privilege and Christian supremacy.
Yeah. Last question. Is this really the last question, Lauren? Yes, it is. Okay. This is from Phil Monroe, a regular viewer to Ask an Atheist. Phil Monroe asks, it is hard to be optimistic about future rulings with the current... is it hard to be optimistic with the current judges? How do you people, especially our legal team, how do we keep a positive attitude?
I mean, I think we've been, this court has been bad, and the judges that are getting appointed for lifetime appointments are going to have a lasting impact that will be bad for state-church separation. But I think there's another piece to this, which is that the judges are one aspect to this country, right, and to how our government functions. We have leaders who are becoming increasingly, or at least there are people becoming of age to become into office who are increasingly less religious. I think overall religion maybe has not been as important to a number of institutions and people in this country as it has been. So I think as it's true, I do have some pessimism about how well our courts will handle cases and some of these issues. But maybe we don't even get there in some respects, because if we're going to have less violations because people understand more that we're a pluralistic country and we shouldn't be doing some of these things, that's probably the fix that we can all at least work towards now. So I have some pessimism about how our courts will interact with our establishment clause, but not necessarily how governments will interact with religion in the future.
Yeah, I think that's right. It's, we kind of stay optimistic by figuring out how we need to shift our focus. And in a lot of ways, this is a very dire and serious time, and we're not the only ones in this boat. I mean, minority rights of every stripe are not faring well at the Supreme Court right now and won't be for the near future. So it's more grassroots efforts. It's more efforts at a local or municipal level, or taking cases at the state level under state constitutions, figuring out new ways to be effective, because here's what we know. We know that like they have been for decades, the pews are emptying. People are becoming more secular. Millennials are the most secular generation in history. And so the demographics are trending, I think, in favor of a more reasonable public and electorate. And so we just kind of need to find ways to harness our efforts and message that doesn't necessarily rely on the Supreme Court doing the right thing.
So the courts have not caught up with the culture yet. Who's going to win in the long run, basically? That's why we're optimistic. Right now, it looks like We have some losses. And FFRF, by the way, has had some serious losses, but on balance, we have more wins than losses. Since Trump was inaugurated, I think we've had, 13 victories and 3 or 4 losses since that time. So we have a good batting average, and it hurts to lose.
It does.
But let's remember, we are winning most of our cases.
Right. And I mean, when we took this case, it was a really different picture, and we were winning this case up until, an intervening Supreme Court case.
Yeah.
So it happens, but...
So we can't have faith, but we can have hope. Is that what we're saying?
Yes.
Okay. Well, anything else, or shall we wrap it up?
Wrap it up.
All right.
Let's do it.
So you stayed awake, Patrick.
I got some
he's
sleep
just
with my
sleeping
newborn.
with his eyes
yeah.
open.
Yeah.
Yeah,
You
with
notice that?
a newborn in the house, it must be. I know that feeling. So congratulations, Patrick. So, and thank you for watching. That's our show for today, and we invite you, if you're interested in these topics, you can become a member of the Freedom from Religion Foundation. You can help us in our vital work to keep state and church separate, and to educate the public about the views of non-theists. Visit our webpage at ffrf.org, or you can just pick up the telephone and call 800-335-4021.
And one way you can help FFRF is by contacting government officials who violate the law. If you want to receive FFRF action alerts on your smartphone, to do just that, text FFRF to 52886. Data rates may apply. Again, that's FFRF. Text it to 52886.
We're taking a summer break next week, but we'll be back on August 28th with another episode of FFRF's Ask an Atheist.